Good evening. Honorable Chief Justice of India, Justice Deepak Mishra, Honorable Judges of the Delhi High Court as well as the Supreme Court, Senior Minister of State of Singapore, Ministry of Law and Finance, Ms. Indrani Raja, SIAC Court President, Mr. Gary Bond, SIAC Court and Board members, ladies and gentlemen. I take this opportunity to welcome you to the SIAC Heart Talk 2017. To all our international guests, whom I did not get to welcome during the afternoon, a very warm welcome. Before we begin, I request you to kindly turn off your mobile phones and any other electronic items or put them on silent mode. Thank you. We are indeed privileged and honored to have amongst us such distinguished guests. Without further ado, I would like to invite Mr. Rajiv Luthra, Member SIAC Board of Directors, to give his welcome address. Mr. Luthra.
My lords, ladyships, excellencies, my seniors, ladies and gentlemen, a very good evening to all of you. Thank you for joining us and a very warm welcome to all. I know it has been a fun day of games at the SIAC India conference so far, but now it's time to get down to the difficult conversations and the naughty questions at the SIAC Hard Talk 2017, after which you'll be happy to note we'll all be breaking for a well-deserved round of drinks. Gary Bond's Game of Thrones-inspired prophecy from 2016 that winter is coming will be put to test by our panel this evening, and we will discover whether, like the best prophecies from that series, is to be taken literally or interpreted with more nuance. We are lucky to have with us a distinguished panel to discuss the question, is this the start of winter or will it be a long golden summer for international arbitration? This panel, ladies and gentlemen, includes, of course, Gary Bond himself, senior counsels from not one, but two jurisdictions and a QC. One of the panelists, in fact, has a very special qualification. Many, many accolades he's received during his professional career, but his latest big one, and that is Mr. Toby Landau, the latest QC, the latest big one is that he's been admitted as an intern to Luthra and Luthra Law Offices this morning. And he has the leave of permission of the managing partner to attend this conference, so that's why he's here. He was cleaning windows till now, but he's here with us. Before we get to the panel discussion, however, we are lucky enough to have addresses by two eminent members of the legal community from Singapore and India. To deliver the opening address, we have Mrs. Indrani Raja, Senior Counsel, who is also Singapore's Honorable Senior Minister of State, Minister of Law and Finance. Ms. Raja, it's an honor to welcome you. If I might say so, it's a great relief to greet you on this occasion as a distinguished guest, rather than as a formidable opposing counsel, which you have done in the past with me, and we've had our knees shaking. We are also extremely fortunate to have with us the Honorable Justice Deepak Mishra, Chief Justice of India, who has graciously consented to deliver a special address as well. It is indeed an honor to have you amongst us, sir, and thank you for taking time out from your pressing schedule to be here. We look forward to hearing your thoughts on arbitration and India, and hope you find the discussions this evening stimulating. Now, before we dive into the proceedings, I would like to take advantage of having the floor to say a few words. The key feature of arbitration in India at an institutional level is that it's a win-win for all parties. For Government of India, it's a way to improve the ease of doing business in the country. India moved up 6 paces between 2016 and 17 when it comes to enforcement of contract, but it still leaves us at the rank of 172. Allowing parties effective recourse to arbitration is one surefire way of boosting India's rankings. For the judiciary, it helps relieve the burden when it comes to pendency, which is one of our most serious issues. And for litigants, it provides an efficient form of recourse that is trusted by all parties. What is needed in India are two things. Most certainly, the arbitration awards will be respected and enforced, better infrastructure. I'm happy to note that in 2017, so far been a good year on both counts. We, that is SIAC, has established an office in GIFT, which is the International Financial Center in Gujarat, 2 months ago. And hopefully more plans in the pipelines for integrated developments where arbitration centers coming up in major Indian cities. Delhi clearly is one of them, close to the airports and with cost-effective venues with high availability. This will allow India to take advantage of what I like to call its temporal and geographical dividend. The advantage it has by way of its time zone and physical location between major financial centers. During Indian business hours, India is the only country in the world that you can speak to both New York and Tokyo. Of course, Singapore and the others, London, etc., fall in between. And let's not forget a huge group of highly trained English-speaking lawyers. All we need to do is take advantage of these natural advantages. I'm therefore highly optimistic about SIAC's prospects in India. This is already borne out by our growth in 2016, which saw 58% more Indian parties file new cases than 2015. I'm quite confident that once we have the figures for 2017, we'll see a further growth. On that hopefully positive note, I once again welcome you all to this evening of Hard Talk on the future of international arbitration. Thank you all.
It is my pleasure to now call upon Ms. Indrani Raja, Senior Minister of State of Singapore, Law and Finance, to give a keynote address. Ms. Raja.
Honorable Chief Justice, Mr. Justice Deepak Misra, Chief Justice of India, Honorable Madam Geeta Mittal, Acting Chief Justice of the Delhi High Court, Honorable Justices and members of the Indian Bar and the International Bars, members of the SIAC Court and Board, Ms. Lim Seok Hui, CEO of the SIAC, distinguished guests, ladies and gentlemen. This is the Hard Talk session, being the second part of SIAC's day-long conference. Earlier this afternoon, in the conference segment, we did some crystal ball gazing to consider the future of arbitration, particularly between India and Singapore. My conclusion in my earlier opening address was that the future of arbitration in India is bright. It will be an important part of India's rise and internationalization, and Singapore and the SIAC can play a role in facilitating this. However, as we all know, all good things are not without challenges. In my remarks for tonight's session, I would like to address some of the issues faced by the arbitration industry and address them directly, this after all being a hard talk session. As mentioned this morning, the world's center of economic gravity is in Asia. The hive of activity in Asia is reflected by the increasing disputes here. The Global Arbitration Review updates arbitration caseloads regularly. From 2012 to 2016, there was a 37% increase in caseload administered by 11 arbitration institutions worldwide. But if you look closely at the split between Asian and non-Asian institutions, you will see that caseloads by institutions outside of Asia grew overall by 13%, whereas the caseloads by institutions in Asia grew more than 75%. This is no surprise. The Asian Development Bank calculated that Asia accounted for nearly 2/3 of global growth last year. As Asian economies grow, we will see first the rising presence of foreign companies meeting the needs of a wealthier, more sophisticated domestic market. And second, local companies are going global. Growing cross-border commercial activity means growing cross-border disputes and growing demand for arbitration. And this is not even accounting for future projected growth. For India, growth will be facilitated by the economic policy foundations laid by Prime Minister Modi's government. In China, new opportunities will arise from the Belt and Road Initiative. And for ASEAN, as the region integrates, the ASEAN Economic Community will generate even more growth. All these augur well for the need for dispute resolution. The facts and the figures indicate that the sun is shining brightly on arbitration. These are the signs of summer. But the question is, what part of summer? Is it the beginning, with arbitration on the ascent, or is it at the end of summer, with decline around the corner and the advent of winter? The facts I cited present opportunities, but they also generate stress on the market. First, there's the issue of basic supply and demand. There are only so many high-quality arbitrators in the world. Many of them are sitting in the room today. And it takes longer to train a top-notch arbitrator than it does to grow a company. I'm sure that the people here will not disagree. This results in the same arbitrators being appointed for multiple cases. We should not be surprised, therefore, to hear increasing concerns about arbitration as a mode of dispute resolution in terms of rising costs and increasing delays. One natural response to this has been the increase in the supply of arbitration services, a rise in the number of Asian jurisdictions developing dispute resolution services and innovations to address this demand. There's also a growth in the number of arbitral institutions, and top arbitral institutions like the PCA and ICC are expanding their global presence. However, a trend that should be of concern to arbitrators is the rise of competing dispute resolution models. Litigation is fighting back. The wide enforceability afforded to arbitral awards by the New York Convention has long been a bulwark of arbitration's popularity. However, there are now new instruments for international enforcement of court judgments, an important one being the Hague Choice of Court Convention. Signatories include the EU, US, Mexico, and Singapore. It has gathered pace in recent years. The EU, Mexico, and Singapore have ratified the convention. Last month, China signed the convention. On the mediation front, there are now discussions about an equivalent to the New York Convention, i.e., a multilateral agreement on the enforcement of settlement agreements arising from mediations or conciliations. And consider, on top of this, other global trends. As Mr. Gary Bourne mentioned in this afternoon's session, there is growing resistance to arbitration in the area of investor-state arbitrations. Some states have voiced opposition to arbitration, in some cases citing factors that were the very reasons why arbitration came into being in the first place: confidentiality, the lack of a right to appeal, and a sense, rightly or wrongly, that awards against states have been disproportionate or unjustifiable. It is against this backdrop that the EU is now discussing a multilateral court system. This presents further competition to arbitration, which has dominated cross-border dispute resolution since 1958. Then, there is technology. Technology is changing the legal sector. Clients demand value and speed, and are increasingly capable of parceling out work to machines which can meet their needs. Technology will not replace lawyers, but technology will increasingly augment the arbitrators' and the counsel's roles. Courts are increasingly moving into e-filing and technology courts that provide convenience for parties and counsel. There will be pressure for arbitrators and arbitration institutions to do the same. Artificial intelligence, or AI, is making ever-increasing inroads into discovery, case analysis, and research. Clients will no longer be willing to be billed by the hour for such work which can be done manually, if software solutions can turn up the same results in a matter of minutes, if not seconds. In the US, there is a software known as Lex Machina. It predicts the outcome probabilities of cases using data aggregated from past cases. This could impact expensive pre-arbitration advisory opinions. In the US, there's also another software called Premonition Analytics. It mines data to inform users which lawyers win before which judges. That basically means your clients would run a search to see your win-loss record. For arbitration, it may be a little bit more difficult because of confidentiality, but that doesn't mean that they cannot get the information from elsewhere. There's another US startup, Ravel Law. This mines data to reveal insights about judges, lawyers, parties, and subjects of cases. And whilst arbitration is confidential, one can well envisage in the not-too-distant future someone will start aggregating data about arbitrators, counsel, and parties based either on publicly available information or using an Uber-like software to rank arbitration professionals based on clients' direct feedback. So these are some of the challenges that face arbitration today. So what can you do? Perhaps I can share a Singapore perspective. Singapore is a small country. We have no natural resources. If nothing else, our situation has forced us to be very practical about things. What is our assessment of the broad parameters? Well, the trend of globalization will persist, notwithstanding the inward turn of some countries today. It has brought prosperity to millions, if not billions, of people. The global trading regime is here to stay. At the same time, technology is developing at an accelerating pace. It will bring us to places we cannot yet imagine. So you can do your best to prepare for them, but sometimes it's like crystal ball gazing. What is beneficial and what is disruptive? Who will benefit and who will be disrupted? We don't quite know the full picture. And then there are the concerns of the arbitration clients, which I highlighted earlier. The conclusion is that dispute resolution, and arbitration in particular, remains critical to the growth of global commerce, but it must be responsive to demand and user requirements. In order for arbitration to not only survive, but thrive, it must innovate to meet customer needs amidst changing trends. Hence, in Singapore, we have had to, in recent years, make several changes to keep up with the evolving landscape. There are disputes where parties need emergency relief even before a tribunal is formed. This used to be a bugbear in Singapore arbitrations when parties' activities in the interval before the appointment of the tribunal could adversely alter the situation in a way that would not be easily compensatable in damages or would present the other side with an irreversible fait accompli. So SIAC introduced the emergency arbitrator mechanism and was the first arbitral institution in Asia to do so. In December last year, SIAC launched their investment arbitration rules, which seek to improve on existing frameworks. Most recently, we amended our legislation earlier this year to allow for third-party funding for arbitration. For those less familiar with third-party funding, allow me to elaborate. Third-party funding is a situation where an entity unconnected to the dispute provides funds to a party to pursue a legal claim. This typically addresses a situation where a party has a good claim on the merits but has insufficient funds to pursue it. The claimant uses the funds to cover its legal costs. In return for funding, the funder gets a share of the amounts awarded to the claimant if the claimant is successful. If the claim fails, the funder goes without reimbursement. Hence, the risk is assumed by the funder. We made this change in response to feedback that there was demand for such funding in international arbitration cases, and we expect this to spur more international arbitration cases in Singapore. But responding to change is not simply about fighting a rearguard action. It is also an opportunity to innovate and move ahead. Arbitrators and Arbitration Council should be prepared for change and ride on it. Arbitration is still popular for good reason, but users have said, and you must respect, that it is no longer the only game in town. Being cognizant of this, we in Singapore have consciously developed alternative products for dispute resolution. In this way, clients have a suite of things from which to choose depending on what best fits their needs. So in addition to arbitration, we have the Singapore International Commercial Court, which we established in 2015. This is a neutral, high-quality forum for cross-border commercial litigation, where jurisdiction is conferred purely by consent of the parties. Likewise, we set up the Singapore International Mediation Center. Mediation is slowly but surely growing in popularity as a mode for dispute resolution. To capitalize on the advantages of mediation but provide cross-border enforcement, we introduce the ARB-MED-ARB procedure, which has been extremely well received by parties. So in conclusion, the answer to the question of whether what lies ahead of arbitration is a long, gradual decline into the frozen wastes of winter or an ascent into the bright, shining golden summer is that it really depends on how the arbitration industry, the institutions, the arbitrators, and counsel respond to the needs of parties and to the changes that will inevitably be wrought by technology, a changing world economy, and international considerations. So the future, ladies and gentlemen, is in your hands. Thank you very much.
Thank you, Ms. Raja. May I now call upon the Honorable Chief Justice of India, Justice Deepak Mishra, to deliver his special address. Justice Mishra.
The esteemed Minister, Justice Sikri, Justice Geeta Mittal, Honorable Acting Chief Justice of Delhi, Honorable Judges of the High Court of Delhi, ladies and gentlemen, I was really not very sure whether I should attend this function or not. I had a dialogue with my colleague, Justice Sikri. He said, I must understand the SIAC perspective as they are having a chapter in India, and I must apprise everyone present over here about the Indian perspective. The Honorable Minister has twice used the words arbitration industry. I was slightly taken off my thinking process. Why did she use the word arbitration industry? I had seen the latest rules of SIAC when she explained about the third-party funding that you really can invest, about the fruitful result of an arbitration which is likely to come in future. It's an investment, and therefore it's an industry, and I must welcome the thought and appreciate it. You see, there is a perception, I must say without any kind of innovation, that there is a prejudice that our country is not arbitration friendly. That is why it may not be a good country for investment or having a seat for adjudication of arbitration. I must, and I am obliged to, dispel such a kind of thought. You see, we have the centers growing up throughout the country. As I understand from the perspective of the government of India, it's opening its windows for all kinds of investments and making legislations so that the country becomes arbitration friendly, number one. Number two, the 2015 amendment, there are some litigations pending in courts in certain spheres, but still, the fundamental purpose of those amendments are, first, to reduce the delay in arbitration. This is arbitration as a concept was conceived throughout the world, wherever it was from the days of ancients till today. The parties do not get into litigation and choose their own arbitrator or a decider whose award they shall accept as final because they have the faith in him, the trust in him. The delay actually spoiled the arbitration to a certain extent. The present statute takes care of that delay. It fixes a time limit that the arbitrator is bound to pass the award within this specified period. It also takes care of another thing. You see, the delay, a ma'am were uttered, and I must appreciate, the cost-effective arbitration. If the delay continues or the arbitration proceeding continues for long, it's very difficult to afford it. Any proceeding, any litigation, and especially arbitration has to be cost-effective. And therefore, the legislature has said there is a cap. You can't charge fees beyond this. And there is a, if I really coin this phrase on the spot, there is a legislative bonus towards the speedy arbitration. The arbitrator who decides expeditiously following the norms of arbitration, he has to be given some kind of a benefit. And third, you see, the problem of arbitration in certain countries as well as in here, which I would like to name it as ethicality of arbitration, the morality of arbitration. When I say morality of arbitration, I do not say the arbitral proceedings. I'm talking about the persons who really function as arbitrator. Therefore, the 2015 Act of ours scales down who can be eligible for arbitrator and who can't be. That is where I must repeat that or echo that concern. The trained arbitrators, the good arbitrators, the schooled arbitrators come into the forefront. Not that you can choose X, Y, or Z as an arbitrator. The recent amendment also protects the interest of the beneficiary, of the person who has got the award in his favor. It's still under debate, but still, as far as this act applies, under the 1996 Act, moment the award is filed, an objection is filed, there's automatic stay. Now we do not have. The purpose is to compel the party to deposit the amount so that the other side can withdraw. I'll tell you my recent experience in two cases. There was a foreign award. $6 million in one case, the other was $4 million. We direct the parties to deposit and the other party to withdraw 50%. What we call in our language is a peremptory order. If you don't deposit, the appeal stand dismissed. In one appeal, they deposited, the other appeal, they did not. The consequences followed. The purpose of saying all this, India is growing arbitration friendly, and we are also having a center which is controlled by the Supreme Court for the present. Justice Sikri is the chairman of the committee. I'm ex officio, the patron-in-chief, and we are sure that will be a world-class arbitration center, and definitely we have a friendly relationship with SIAC. You see, we had a very vague concept, a very amorphous concept under the 1996 Act with regard to the conception of public policy. Anybody could stand up and say this is public policy. Now, in 2015 Act, it has been crystallized. It has been narrowed down that yes, this is public policy. The challenge is narrow. Another aspect I would like to highlight from the Indian perspective. Here, the lawyers who are present here, even the corporate lawyers, they have a role. They must also understand a lawyer also is expected to be arbitration friendly in the sense, if you understand this award is not interferable and there is no scope for interference, they must so advise. The challenges goes on one court after the other, and that is what consumes the time. They must also advise that I agree with the Honorable Minister. We have the provision in the Act, I think Section 30. During the arbitration, there can be a mediation. In India, I must tell you, I'm not saying there is any kind of competition between arbitration and mediation, but definitely mediation is also engulfing the commercial disputes. I must say, Delhi High Court is doing excellently well in all kinds of mediation, including the commercial dispute mediation. Delhi High Court has an international arbitration center, and we are fostering mediation, and simultaneously we are trying to say that arbitration also has to be enhanced. We recognize foreign jurisdiction when there is the contract. We had a constitutional bench decision in 2012 which stated, yes, when there is a foreign award, there can be no scope of interference by the municipal courts. Then, that was further dissected that if the parties have chosen either consciously or expressly, or there is implication, implied consent, that they have chosen, say for example, SIAC or some other jurisdiction, London, it will go to London. 2-3 years back, in the span of 3 years, I know how difficult it is to state in clear-cut terms what the party meant when there is no express consent with regard to be guided by a particular jurisdiction. But still, we try to enter into the intent of the parties from the articulated language in the contract and say, no, Indian courts have no jurisdiction. The courts in London or Singapore have jurisdiction. We are not traditional or conservative. No, we have the jurisdiction. This chapter has opened. Mr. Luthra has given a very good introduction about the perspectives. But I was slightly surprised why everybody was talking about the winter. Where is the winter? You see, there is I must now share a different kind of analogy with you. There's an American novelist who got a Nobel Prize for the book called The Winter of Discontent, the John Steinbeck. We are not writing any kind of novel over here. The novel is progress. I don't conceive that arbitration can ever get into winter. It's always in the midst of summer. And therefore, we must have a note of optimism that like in Singapore, in India, there can be cooperation. And we don't envy SIAC. We don't envy Indian part because it's our own country. Both can be hub of international arbitration. Thank you for calling me. Thank you.
Thank you, Honorable Chief Justice. We couldn't have asked for better advice coming from anyone better than him. It has indeed been a privilege and honor to have you amongst us today. It now brings us to the much-awaited Hard Talk session. The theme for this session is this the start of winter, or will the long golden summer continue for international arbitration? Without giving much away, I would like to call upon our moderator for this session, Mr. Vikram Nankani. And of course, on the panel for the session, we have Mr. Gary Bourne, Mr. Toby Landau, Mr. Darius Kambata, Mr. Christopher Lau, and Ms. Rohini Roy.
Good evening, ladies and gentlemen. Just waiting for everyone to settle down, especially at the back there. Time to get on with a hard talk. I'm really privileged and flattered to be amongst the galaxy of superstars, let me assure you, bigger than Bollywood. And yes, they don't need introduction. Each one of them is a superstar in his own right. And so without much ado, let's kickstart a discussion which I must say the Honorable Chief Justice has already set the ball rolling when he said he doesn't see the winter at all. Sorry, Gary, if that is where he is sealed the fate of this discussion, I'm sorry to say that, but let's nonetheless start with a little bit optimistic note. We really are in a position today where there is a seesaw kind of a situation. In some parts of the world, and India definitely included in that, we are seeing a thrust in arbitration, be it the 2015 amendment of which the Honorable Chief Justice spoke about. He gave you the salient features, be it the new act on commercial courts, be it the Justice Sri Krishna recent report of August 2017, which sort of highlights the institutionalization of arbitration in India, and of course the pivotal role which judiciary is playing in adopting a more proactive and pro-arbitration stance. We definitely see the same kind of fervor in other parts of Asia and Australia, where we've just heard that Singapore and Hong Kong have introduced third-party funding. India can't be far behind, and I'm sure we will overcome our traditional concepts of champati and maintenance. We have Australia tweaking its law to make it more friendly, especially on the enforcement side, and of course Myanmar and other parts of the world introducing new legislations. On the other hand, of course, we have Lord Chief Justice of England and Wales, Justice Thomas, in his speech, famous speech, which is now in March of 2016, where really he said that arbitration is coming in the way of development of commercial law by English courts, and that has been taken by many quarters to be a criticism against arbitration and a preference towards court litigation. And then, of course, there is serious criticism against arbitration in the investor-state dispute settlement. We have had the transparency rules on treaty-based arbitration to somewhat balance the situation. So such measures are being taken, and it is in this background that in an interview which Gary was giving in New York, where he said, taking inspiration from the famous US series Game of Thrones, said, winter is here, and maybe the long golden summer of arbitration is not going to continue for long. We have, of course, Gary here, but we have other panelists, and therefore the first obvious temptation is to invite all the other panelists to say whether they agree or disagree with Gary. And please, it can't just be I agree or I don't agree. I'll take you back to school. You will be given marks for reasons, not for your answers. So reasons are what are more important. Can I start with the only lady on the panel first? And Rohini, what's your take on the topic that we have?
It's always uncomfortable to be the first one to be asked on something. But let me take advantage of my minority status in the panel and being the only pink amongst the blacks. I read the introduction and the speech by Mr. Bourne with a lot of interest, not only because it bears a reference to the very celebrated Game of Thrones, but it's interesting to see how perspectives can be based on certain similes and certain analogies can be drawn. I read those parts with particular interest where he has said that there is an undead army which awaits across the wall. It seemed to me at first, I was enjoying it more like the series, but later I somehow think that the undead army was probably created by one of us. Even in the sequence and even in the serial, this undead army is actually a creation of the masses. So it brings me to the premise of the day, and I'll try to be short about it. Indeed, seasons would probably change, and there is very little that we can do to help transient phases in life. And so seasons will continue to change, businesses will continue to do business, and being someone who hails from the business community, and that's my second minority status on the panel today, I think that it would suffice to say that the only thing that gets left behind in this race is perhaps the legal fraternity, because it is true that no matter how many seasons change and no matter what kind of winter we experience, businesses will still try to concentrate on what they do best in terms of economic growth and revenue generation, and somewhere between the divide of revenue generation and disputes, we always prefer using revenue and cut out the disputes. And so the first thing that to set the ball rolling that I must say, is that perhaps we should start taking more inspiration from the story of the ant and the grasshopper. Was it where the grasshopper is somebody who doesn't really prepare very well ahead for the winters, and so obviously doesn't have a very pleasant experience of the winters, and there's not much that we could do in terms of stopping the winter, but I think that we can make it a very cozy and comfortable winter if we start preparing well ahead in summer. It is a fact that the business community today values sentiments, business ethics, much more than dispute resolution. There are very, very often when we sit across in arbitrations, we feel that the level of animosity is actually much higher than what we really feel in our hearts. And very often, dispute resolution is actually to create relationships even out of the dead ones, and to make sure that they keep coming back to the table, and perhaps just a small negotiation tool, and not so much meant to fight tooth and nail.
So Rohini, sorry, so you're going to the root of the whole thing, and you're saying the businesses aren't looking at disputes, and if there are going to be no disputes, there's no question of summer or winter, there are just going to be no disputes, that's it. So, Christopher, do you see the writing in the same way on the wall? The pun intended, Gary, sorry.
I actually agree with Gary, not because it's the easiest thing to do, but because there's a lot of sense in what he says. He quoted Frank Underwood in The House of Cards, which is what does he tell us? And that is that in life, there is only one rule. And that rule is hunt or be hunted. And the time has come to stop being hunted. You face down your adversaries or face down your critics. You respond and you innovate. And in that way, you can prevent the onset of winter.
Yeah, but please see the number of filings that each of the institutions have, whether it is the Asian institutes like SIAC or the HKIC, or the other institutes in other parts of the world like ICC or LCIA. The numbers seem to be rising, and there is a hope that 2017, as Rajiv Luthra said, would be in fact better for SIAC over 2016. Toby, what is your take on this?
Unusually, I am in complete agreement with Gary Bourne.
Oh my God.
But I go a little bit further. I don't see that the numbers are a source for confidence for us. There are a lot of numbers because people resort to arbitration, not because they love arbitration. They resort to arbitration, as they always have, because there is, at the moment, simply no alternative. If you want a binding, enforceable system of dispute resolution across borders, and you're not going to submit yourself to the courts of your adversary, then you arbitrate. Now, that doesn't say anything good about arbitration. It just tells you there's nowhere else to go. But the phenomena here, I think, is actually a rather significant phenomenon. What I see is that over the years, we have collectively, as the arbitration community, developed an increasingly settled, harmonized system. We all know how arbitration now runs, how it should run. We've harmonized our laws. We all know each other. We confirm each other in our ways at conferences, increasingly once a week, in increasingly exotic locations around the world. The subjects don't change. The speakers, sometimes you're speaking, sometimes you're listening, but it's always the same topics, and we talk about them, and we reinforce each other. And we trumpet and we celebrate that we have a harmonized system. But that system is the very system that actually outside of this closed community is now being questioned, seriously questioned. It's been put to the test by investor-state arbitration. We all know that that has pinpointed its weaknesses. But the dividing line between investor-state and international commercial arbitration is by no means a clear one. And so all of us in the Mutual Association for International Arbitration, sometimes abbreviated as MAFIA, have got to actually see how serious this is, because we're fine as long as there is no alternative. But now that people are looking for an alternative, that may well signal an end to our cozy system.
Great. I mean, that's as candid as it can get, coming from an arbitrator, an established arbitrator, and an arbitration practitioner, to be that you hold these views. And I think your views are somewhat echoed in Lord Thomas's, both his speeches in the Bailey Law Report and also in Beijing, though people say in Beijing he retracted, but I think it's basically there he was selling London, so the speed was different, and here it is different. And going by what the closed-door justice system that you spoke about, Daraj, do you have a different perspective from an Indian?
You know, Vikram, you said to go back to school, and I'm going right back to school, and I think we were taught that when you have winter in one hemisphere, that inexorably means you have summer in the other. And I think that's what's happening globally. There is a shift because of globalization in the economic powerhouses. And we heard statistics now to show that Asia is the powerhouse today. So viewing this from an entirely Western perspective might be seeing it through colored glasses. India has had a love-hate relationship with arbitration. We were amongst the first countries in the world to ratify the New York Convention, and we had a 1961 Act come right up after 1958. But that's not to say that we've always completely respected the sanctity of foreign awards. We've had our ups and downs. It's safe to say that now India has wholeheartedly recognized the importance of arbitration and the importance of respecting foreign awards. And we've seen that now in the pro-arbitration stance of all our courts, particularly our Supreme Court. And And the Chief Justice you heard threw down the bond letter. I think you should pick that up. Because we know Balco, we know associate builders, and we are all familiar with the 2015 amendments. Someone also spoke of Justice Sri Krishna's recent report. All this shows that Indian arbitration is moving forward into what I hope and what many people believe will be broad, sunlit uplands rather than a winter environment. That's not to say it will be easy. Lawyers have to be arbitration friendly, again, as the Chief Justice said, and many of us are not. So I think the challenge before us in India today is for lawyers to adopt the best international practices and to become arbitration friendly. But I don't share the pessimism of my friends on this panel. And I certainly don't tar international commercial arbitrations with the same brush that people would tar investor-state arbitration. The issues there are distinctly different. There is a public law element in investor-state arbitration which might question the very premise of having arbitration at all in that field. And that's an issue that's going to develop, and many countries have not accepted that. Brazil has never accepted the concept of arbitration in investor-state relations. India did in 2003. We pulled back in our recent model treaty. But I think investor-state arbitrations ultimately are a reflection on what a country believes it has to do to attract investment. If it doesn't have to go the arbitration route, it won't. That can't detract from certain core themes like party autonomy, the right for two traders or disputants to refer their disputes to a private forum of experts. Now, do I share the pessimism of Lord Chief Justice Thomas? I have a response to that. He calls for greater judicial review of awards, and he's worried that the common law won't develop because of arbitration.
Yeah, they have single-digit filings under whether it is Section 67 or 69.
Wow, are we turning full circle? Because that was the view of many Indian courts till a few years ago. There was a general insecurity about arbitration and an anxiety to have greater judicial review.
That's
so
right.
Were we doing something right?
I mean, can you imagine in India, Section 34 applications, just 6 to 7% arbitration awards are taken to the courts?
I think it's a matter of perspective. I don't think it's going to be it's not going to be roses all the way.
Right.
It's a matter of perspective, and it's economic growth that will fuel arbitration, and that's the figures that SIAC has today.
Sure.
Show that.
Just to clarify, my message is not one of doom and gloom. So it's not one of that this is all cataclysmic and our system is falling apart. My message is a little bit more subtle, actually, and that is that what we have to do at the center, in a sense, of this field is to wake up. Once we wake up, this is the moment to actually improve our system. It's not signaling the end of it. It's a matter of actually opening ourselves up to a different way of seeing our own process. Now, I don't share Lord Chief Justice Thomas's views, actually. His view was there should be greater court interference, essentially, for the good of the common law. So that's not my message at all. But what I am focused upon is a complacency in the field. There's a resistance amongst international arbitration specialists to actually question themselves. And it's that resistance which has given rise to a backlash. So once we actually wake up to the backlash, it will be for the good of the process.
Yeah, so before I get Toby in, and before we hear it from the horse's mouth, and this time no, pun not intended, sorry, the scorecard at the end of round one is this, that you have one gentleman on my left, which is Christopher, taking a very categorical stand that he agrees with Gary. Rohini, kind of a neutral position. And then we have Darius taking a very clear Indian stand. And if I can pull in the Honorable Chief Justice into this discussion and add weight to what Darius says. So we have two Indian who spoke about the Indian summer, everlasting Indian summer. And then, of course, we have Toby, who is a typical example of an Indian politician who, in his first reaction, said something, and then there was a caveat and a rollback in his... Yeah, that's right. So Gary, how do you react to this? Has the season changed since May 2016, or you still maintain what you said?
So I disagree almost entirely with the way that my position was put. That is to say, I wholeheartedly reject the proposition that either winter is here or winter is coming. My speech asked a question, it didn't give an answer. The question was, is winter coming? I haven't heard, including from my very good friend Darius, much to assuage my concern that winter might be coming. We hear that if it's winter in the northern hemisphere, it must be summer in the southern hemisphere. And thus we can, at least in this room, all relax. We should tell that to the multiple Latin American countries, African countries that have denounced both their bilateral investment treaties providing for arbitration of international disputes and withdrawn from ICSID. Last time I looked, they are in the southern hemisphere, and thus simple geographic analogies can't provide us much comfort. Still, I think what both Senior Minister of State Indrani Raja said and Chief Justice Misra said, taken together, and for me that's extraordinarily important, taken together, do give us comfort that the answer to my question, is winter coming, should be no, not just no here in India, but everywhere in the world. They put together, from two separate perspectives, the two pieces of the puzzle which are fundamentally important. The first piece of the puzzle is us in this room, the arbitration community. And it is us who must produce the arbitrators, the short supply of that we've heard about. In my experience at SIAC, some of our best arbitrators are young arbitrators. We have a SIAC program tomorrow in which we further train young arbitrators. They are the future, and I think we as a community must have very much in mind training them and also improving our processes. But that's only half of the equation. The other half of the equation is states. Arbitration is not some international institution floating in the ether. It is a public-private partnership between courts, most importantly, as well as legislatures, and us, the arbitral community. Without the support of courts, arbitration is not of much use. I was therefore enormously heartened by Chief Justice Misra's comments, by Darius's comments, that India is arbitration friendly, because unless states are arbitration friendly, like India, like Singapore, then arbitration won't flourish. But if working together, the arbitral community and national legislatures and courts put their mind to it, this summer can continue. I'm reminded of, if you've seen season 7, Ms. Stark's comment that when the winter winds blow, the lone wolf freezes and the pack survives. What ultimately that means is cooperation will enable survival of the winter, and lone wolf tactics will ensure failure. I hope that's responsive.
Yeah, thank you. Sorry, Toby, again.
As somebody who has not watched Game of Thrones, can I just say I am totally lost? All right. I thought I was following this when we were just at the level of meteorology, but now I don't know where we are. But what I just wanted to comment was, it's fine to say let's all stick together and be arbitration friendly, and let's, as states, sponsor arbitration and promote it. But what does it really mean? You know, we can sit here with all these platitudes. What does it mean to be arbitration friendly? Does it mean we carry on doing what we've always been doing? If we do that, then winter will certainly be upon us, because we have got a backlash at the moment. You can now, for the first time, go into a black taxi in London, and instead of the taxi driver complaining about the traffic or the weather, he'll complain about arbitration. It's extraordinary, because investor-state arbitration has now hit the headlines. It's all about secret courts. It's about these cabals of people who are acting in the interests of multinational corporations. That is infecting commercial arbitration, because the dividing line is not clear. And a clear example of that is, if you had sat in the UNCITRAL working group when the rules on investor-state transparency were negotiated, there was a huge problem in drawing a line between investor-state and international commercial arbitration. Nobody knew how to draw that line because the same issues were coming up for both. So there is already a whole body of people who are not happy with the system, and it's manifesting itself. We cannot close our eyes to that. And we may say, because we know about it, we may say they're wrong. But being wrong doesn't matter. What matters for the future of our system is perception. Because if people don't trust the system, then it won't survive. And so we've got to actually correct that.
In fact, I had one of those questions on my list here. So for those who are not familiar with the criticism that the investor-state dispute settlement mechanism is facing, it's this, that an example of that is when the Transatlantic Trade and Investment Partnership Treaty was being negotiated. The US stakeholders themselves protested to say that you should not have an arbitration clause in the treaty. And that's the kind of resistance that one would see. But Toby, sorry, I know you just spoke, but I'll come back to you on this same question because you touched upon it. Is it fair to apply the criticism against ISDS to international commercial arbitration? I mean, is it fair to really extend that criticism for the purposes of having notions of winter coming to international arbitration, which is entirely a different ballgame, I understand? So whatever be the criticism, they can be ring-fenced only and applied to the investor-state dispute settlement mechanism. Would it be fair to extend those apprehensions and fears and attacks to commercial arbitration?
So I think that there is obviously a line you can draw between investor-state arbitration and commercial arbitration. So in its nature, both they're different. And the simplest way of seeing that is that investor-state arbitration is essentially adjudication on a vertical relationship, not a horizontal relationship. It is a relationship between a state and an individual investor. And that is more like a regulatory relationship, where the investor is questioning conduct that the state has undertaken, which might in fact impact on a whole population. That's to be contrasted by commercial arbitration, which tends to be a horizontal relationship between two traders at the same level, or indeed two states, not a vertical regulatory relationship. So one can draw that line. But going back to what I mentioned before, when this was actually debated within UNCITRAL, it was quite clear that there's a whole host of international commercial arbitration that impacts upon wider interests, that has at its stake public interest, where the audience can't be confined to simply the immediate disputing parties because the stakes are sufficiently significant or the impact is sufficiently wide. So drawing that line, actually, as a practical matter, is quite difficult. So for example, you might say, well, investor-state arbitration should be transparent. That now seems to be the consensus. But then there's a whole host of commercial arbitration which has a wider impact, which also should be transparent. And then one goes on with the other considerations in the same way.
Yes, that's right. Those who are not familiar with the transparency rules should know that under the rules, all pleadings which are filed before the tribunal inter partes and the evidence can be, in most circumstances, disclosed to third parties. So that takes me to the question, and Christopher, I'll put this to you. Would you then concede that today party autonomy or confidentiality are no longer drivers for opting for arbitration?
I concede nothing.
That is without prejudice to my rights and contentions. That's a popular cliche.
No, I concede nothing. I think, in fact,
sorry.
Can you hear me? It's on?
Yeah.
In fact, I mean, Toby, you mentioned that when you get into a black cab in London, all you hear is very negative comments about arbitration. I think it's true as well. If you get into a cab in Germany, you would get the same comments from the taxi driver. But you get into a taxi in Singapore, you get into a taxi in Japan, in Tokyo, a taxi in Seoul, a taxi in Beijing, you get the entirely opposite comments. They actually say and they ask about arbitration, they think it's a very positive development as a means of resolving disputes.
So Rohini, you as the only user on this panel of arbitration, would you go by the taxi driver's advice, depending on which part of the globe you are? I mean, what would be the considerations in your mind in picking the right forum for a dispute? And as the Honorable Minister said, Singapore may offer you a, sorry to use an Indian expression, may offer you a thali with different varieties and a bouquet of options like, arbitration, international commercial court. In India, you don't. But what would be your factors which you would have in mind in picking one of these?
I'd definitely pick Singapore, just for the record here. But I think it's interesting because just before we get on to that subject, if you allow me, responding to perhaps what Toby said, it's interesting because I feel that international commercial arbitration and investor-state disputes, of course there are comparisons, of course there are things which are common, but what does not run common in the bloodline is that I think that this mistrust and this lack of faith pre-existed and stands very much distinct in the case of international commercial arbitration. Now, we have entered into the fray of investor-state disputes very recently. However, I do realize that this international commercial arbitration users, we are not comfortable anymore signing up for arbitration clauses at all, actually. So my question on whether institutionalized and ad hoc are things which come much later in time, and then comes the question of which institution and why.
You're not saying this because you're in India, and as an Indian you would like to take recourse to the courts because it'll take 7 years, 8 years for disputes to be decided.
No, dehorse that, actually, because...
Okay. So you would still not consider an arbitration clause on its merits, or rather its demerits in the
At times of course we are constrained because working out of 86 countries, you need to have arbitration clauses governing your agreements because not everyone will sign up for the local jurisdictions. So we are constrained to sign up on it, but then I do know that there is an increasing change in this, especially within the public sectors, where there are companies like NTPC, for example, who are very, very big power giants, who've totally scrapped the idea of having an arbitration clause anymore in the contracting in future. So we're actually a little worried because I think this whole thing stems from the mistrust and the faith issue. Nobody trusts them to find a solution, and we're not only looking at the finality of the award, but we also want to know whether the award is worth it, the weight, the money, everything.
Personally, I must confess, this is news to me. It's a different revelation. It's really put water over the Indian summer, the monsoon wedding, probably. But talking about the mafia, which Toby mentioned, would both Gary and Darius, and whichever sequence you want to answer, think that publication of awards would be one way to break the mafia or to improve the quality of arbitration results? Would that be something which you would say yes to or no to?
I'd like to begin by disagreeing entirely with the notion of an arbitration mafia. It may be that very high value international arbitrations, both investment and commercial, tend to have some repeat players. That may be true. That is an extraordinarily myopic view of international arbitration. Literally thousands of arbitrations are conducted around the world, many of them for $100,000 or rupees, many of them in highly specialized fields, be it insurance or maritime or commodities or IP. Trust me, the vast majority of all those disputes, which in turn make up the vast majority of all international arbitrations, don't have the mafia involved at all. Arbitration, and this is part of its secret, part of the reason that it has had a long golden summer, is that it is so flexible and so diverse. It is different things to different people. And it is not true that transparency has carried the day. Many states, particularly in this part of the world, do not in fact subscribe to the notion that investment arbitrations ought to be transparent. They prefer that it be confidential. And I think precisely the same thing applies to international commercial arbitrations with respect to publication of awards. At the end of the day, disputes are disputes between two parties who choose a method to resolve them. Recognition of that autonomy, which Chief Justice Misra so eloquently affirmed, is critical to the arbitral process. And thus, the question of do you or don't you publish awards is ultimately not a question for high priests or priestesses of arbitration to decide, but a question for individual parties to decide in individual cases. And the role of international arbitration legislation and treaties is to give effect to those choices.
Can I just ask, do you say that for investor state as well?
Exactly, because states agree to different things.
I think Gary, I think Gary just answered his own conundrum. It's a matter of survival. There's no question of whether winter is coming or not. Winter comes every year. It's how you survive that winter that faces any service-oriented mechanism which upfront arbitration is. Do I agree with my friends on the panel that practices have to be improved? Of course they do. In fact, they have to improve greatly in India. I said that. And approaches, practices, the way we conduct ourselves in arbitration has to dramatically change, particularly in India. But the point I was trying to make is that that will be driven by the economics of it ultimately. It's ultimately also a matter of trust, as Romani said. You trust the process. And one sign where the Indian litigant has actually trusted a foreign process, the classic example is SIAC. You have a flow of Indian arbitrations that have gone out of our country to Singapore precisely because SIAC has a proven record and Indians trust SIAC. Now, the challenge before us Indian lawyers, and I say so boldly, my friends right here, is to get those sorts of arbitrations back into India. And I don't think it's a matter of a share of the pie. I think the pie is large enough, it keeps on growing. So is winter coming? It should come. The threat of it should always be there because that's the only thing that's going to make everyone improve. But is it going to swamp arbitration? Of course not. And just to end, I share Toby's complete ignorance. I too don't watch Game of Thrones, much to my daughter's disappointment. But I do watch Homeland. And when I last saw Homeland, it ended with what was a very liberal candidate for president becoming president of the US and suddenly turning tyrannical. And I think that was really a symptom of paranoia. And I don't think that the arbitral world has to react in that strong, paranoid way at all. I think we have to recognize that we are part of the dispute resolution process. There will always be courts, there will be commercial courts, there will be mediation, and there will be arbitration as there always has been. And do we have to improve? Of course we do, because ultimately everyone's jostling for that same space. But is it all going to end in some sort of Armageddon? Of course not.
I can see that Toby has been going back and forth on his seat. I'm sure he wants to react to both of them.
No, actually, I'm just trying to formulate an intervention which makes no reference to climate. Just proving slightly difficult. I wanted to come back on one point, from Gary's intervention. The point which we'd been asked, that you'd raised, was about publication of awards. So just focusing on this as an example. I think Gary's point shows quite a difference in perspective that there now exists, especially in investor-state arbitration. The way that Gary's put it, as I've understood it, is to say that investor-state, common with commercial arbitration, is really about individual disputes. And those individual disputes are about the immediate disputing parties. And the immediate disputing parties may not want to have transparency. And one has to therefore accept that there may be differences and there's no sort of overall overarching solution. But the other perspective to that is that when you're looking at investor-state arbitration, it's a classic example where, in fact, we have to question what we are doing. Because in investor-state arbitration, not always, but frequently, it's not just about the immediate disputing parties, because the resolution of the dispute will necessarily have a wider impact. And one example I'll give on that is one case that's in the public domain that both Gary and I had the privilege of sitting together on, which is a case involving Tanzania, the Bywater case. And it's an interesting example. We sat on that as investor-state arbitrators, and it was a dispute between a project company that had gone in to invest in Tanzania in the course of privatization of water supply. And there was a dispute between the investor and the state, and we heard it and we resolved it. There was, after that, a whole load of articles that were published criticizing the way that we had conducted ourselves in that case. I'm not saying that it was correct criticism, but the point that was made was that whilst we had made a determination between an investor and Tanzania, the impact of our decision would be felt by 350,000 water users in Dar es Salaam, because it had an impact on the water policy of the state. Now at that point, one can start to see, well, is this really just about the project company and the state? And if it is, then what happens to all these people outside who feel they haven't had a say or they don't know what's gone on? Maybe once the doors are opened and they have a look at what's gone on, there's nothing to complain about. But if they don't know, then it sets up a tension in the system. And that is a classic example where now, one may say in investor state, one can't apply just the commercial arbitration model. You've got to see it as, for its own survival, as something that's actually different. And actually there are some other interests at stake which have got to be catered for in order to ensure that the system remains robust.
No, undoubtedly, I think that's... sorry, Gary, you wanted to say something?
Just briefly. The important point in investor-state arbitration, and I think Darius alluded to this, is that it involves a choice by a state to submit certain of its disputes to arbitration, investment disputes in the case of bilateral investment treaties. The state's choice in that regard is very similar to a private party's choice to enter into an international commercial arbitration agreement. It is the state in those circumstances which is exercising its autonomy. And that the state's choice in those circumstances, like a private party's choice, may sometimes be to arbitrate and sometimes not to arbitrate. That's inevitable. It is in that bilateral investment treaty where the state can express its policy views about publication of awards, confidentiality, transparency, amicus curiae participation, and other things. Some states desire that. Other states don't. That's an entirely legitimate choice, a choice of private autonomy in the sense by a state with respect to its investment disputes. My only suggestion is we ought to give effect to that as part of the arbitral process, just as we give effect to parties' choices in international commercial arbitration. States, at the end of the day, not a mafia of international arbitration experts, ought to make choices about how they resolve their disputes.
But is it as simple as being a matter of choice? Because I think investor-state arbitration has its own dynamics. I mean, you have a foreign investor who has better rights in that sense over the domestic industry. You have some degree of cessation of sovereignty by the concerned state. And the Tanzania example that you gave, where what the vast majority feels, that's not really reflected into the arbitration dispute. So, but keeping all of that aside, so India is not a party to ICSID at all. And it's now reviewing all its BITs. It's come up with a model BIT, which really has knee-jerk reaction to everything that happened to India. Its experience in white industries, its experience in Devas matter and all of that. So they've removed the MFN clauses. So they have tinkered with the BIT model. So keeping that now issue aside, because I think that's a full day debate which can go on, and especially in the Indian context, and coming back to the issue of publication of awards. Again, as Gary said, leave it to the parties whether they want the award to be published or not. But shouldn't there be default rules in the institution rules to say that the award shall be published unless good, valid reasons are put forth by the parties, which would then allow the institution not to publish it? Christopher, your thoughts on this?
I mean, ultimately, of course, that's for the institutions to decide, but certainly with SIAC, as I understand it, they do publish the awards in a redacted form. so do other institutions. And it's,
Right.
it's a reaction, or not a reaction, but a response to the needs of business, to want to know, in some cases, the basis on which certain, the reasons for how an award was arrived at.
That's right. There's sufficient justification for publication of award, because once it's out there in the open and in the public, the arbitrator will be that much more conscious in writing the award. The quality would improve, the legal principles, propositions, which is later. I know that it's not a precedent. So Rohini, going back to you, would you as one of the users of arbitration would like to have an award in your case published and be open to the world at large?
Actually, I have mixed feelings at this point, because I think being a public sector, you're already under so much scrutiny that it has resulted in a lot of evil coming our way.
Yes, I understand. I'm not talking of the public sector, and I'm certainly not talking of the Indian public sector,
So, yes.
but just as a user of arbitration.
So as a user, yes, because the publication of the awards would also help rebuild the trust factor, because it's open to everyone to actually judge and see for themselves the merits are and what reasoning has gone in. Part of the problem is actually because sometimes the reasoning is given by people who are not experts in the field, and especially because we come from a fraternity of a lot of technical expertise which was required, it does become difficult to assess what kind of reasoning has actually been applied to get a certain result. So the publication process it makes it easier for people to digest how and why the award is written in a certain way, and it does encourage us to have more faith in the system, so yes.
Right, okay. Thank you, Rini. Sorry, Christopher, I'll revert back to you, because the next question is a Singaporean-centric question. Do you think that one of the biggest challenges which comes to arbitration now is with the setting up of international commercial courts? And I ask you this because Singapore has today is proud of both these institutions, the arbitration and the SICC. So do you think one is the threat for the other?
I don't. I mean, the SICC complements the other SIAC in the sense that it offers another range or another alternative form of dispute to parties who want to go to the courts.
Oh, I see. I know. And also we heard the Honorable Minister say that you have the parallels of New York Convention in the form of the Hague Convention.
Yes.
So enforceability should not be a problem in relation to foreign judgments.
In time to come.
In times to come. Yeah. Toby, your views on that?
I think the SICC it can work extremely well with arbitration. In fact, I think we've come full circle where arbitration can now learn from what the SICC is able to do. In the old days, the feeling was that court was overly restrictive and inflexible, inexpert, and so we needed something which was more in tune with the commercial world, and that gave rise to arbitration. What's happened in arbitration is it has become pretty undisciplined. It's become pretty flabby, and there are many reasons for that. Often it is what I would term the curse of the New York Convention, which is that arbitrators are fearful of being interventionist for fear that there would then be a challenge to recognition and enforcement under the New York Convention. So they tend to sit back and they let parties and particularly counsel do whatever they want to do. And I always tell people that if you want to be a good arbitration lawyer, a good litigator, you have to go back into court occasionally and get screamed at by a judge in order to be on your toes, because otherwise you don't get that in arbitration. Now the SICC provides this new forum where it is international, it's neutral, but you have the discipline of court. You can have cases struck out. You can stop somebody from arguing if it's not relevant. You can actually bring to bear that sort of tough process that I think we're lacking in arbitration. And that is another choice that's available. If you don't want it, you don't have to have it. You can go to arbitration. But it adds very much to the availability, the range of options that are there.
Yeah, and of course, I am now reminded of the debate where I heard both you and Gary on an award being enforceable even if it is annulled at the seat, and vice versa, that it need not be enforced even if it is upheld at the seat. That kind of complication should not arise in the case of a foreign judgment under SICC. The rest I'll jump over you and I'll come back to you a little later, but I will now pass on the same question to Gary, not as a panelist alone, but as the president of SIAC. And let me also give you the advantage of rule against self-incrimination. If you don't want to answer.
Let me answer as Gary, not in any official capacity. I think it's too early to tell. A little bit like one has to ask, is winter coming? It's too early to tell how successful SICC will be. It depends on what users want, just as arbitration's future depends on what users want. It is important, I think, for us all to remember, though, that arbitration has never been the only game in town, right? Every country has its courts, and some of those courts, many countries' courts, are very well known for international dispute resolution because they provide a very certain, predictable product, a fixed set of procedural rules, a fixed judiciary drawn from a relatively small, homogeneous body, carefully picked, a fixed set of ethical rules with a small bar. And you pick those countries' courts, wherever they may be, precisely because you get a very known quantity. And it's therefore not correct that arbitration has enjoyed some sort of monopoly. It's always had to compete, and how it will compete against other entrants into the market, whether SICC or otherwise, I think is a question for the future, just like whether winter is coming.
There is a very quick question. Would you like to see an equivalent of SICC in India?
Well, on paper, we already have that, the Commercial Courts Act of 2015, but I
Not
emphasize
really so, not
on
really
paper,
so.
if you read the Act and you read the schedule, it's all there. But the question, as often we ask ourselves in India, is it's all there on paper. Is it being implemented on the ground? And sadly, for commercial courts, the answer is largely no. So I actually see international arbitration being a sort of trendsetter for India, because contrary to what Toby said, I think certain practices in international arbitration now need to be introduced in our commercial court litigation. And when that happens, when there's that sort of osmosis, I think the commercial courts in India will get going. As of now, commercial arbitration, I think, is a surer mechanism for most people who have commercial disputes than the commercial court.
Right. With that, we'll throw open the floor. Yes, Rajiv has already put up his hand before I could complete the sentence. We have 5 minutes for a Q&A. So Rajiv, sorry, can we have a mic, please, here? You could shoot the question to any one of the panelists or to anyone.
Anybody can take this. It's a very quick question. I know it's early times to talk about commercial courts in Singapore, but what is the trend? Can you tell us how many, does anybody know how many cases they are hearing right now in the last, it's 2 years since they've been operational in Singapore, and quite quickly. Do we know the trend? Is it more getting bigger,
Gary,
smaller? Whoever wants to take it.
What I've heard is that the numbers are increasing.
Where?
In the courts. In the courts. Okay. In SICC.
Okay. Increasing means 137 or 130, 300?
I think it's single digit, 10. Sorry? Sorry. Yeah.
So far, there are cases which have been, as I understand it, transferred from the Singapore court into the SICC. 10 cases, yeah.
Yes.
Okay.
Okay. Yeah. Christopher's answer, they're increasing.
Yeah, I mean, game of percentages can be equally mind-boggling as Game of Thrones. Yeah. Anyone else? Anyone else with a question there? You want to get this opportunity again to shoot at this panel, star-studded panel. Yes, sorry.
My name is Rahul Sharma, advocate. I want to know, like, how do you see the future of arbitration in intellectual property right laws, like IPRs?
Okay. Any particular? Dharaj?
I'm not really at all an expert in IPR, so I must start with that caveat. But I think increasingly, more and more types of disputes have been going to arbitration, and that will include IPR as well. There's no reason why IPR can't go to arbitration. That said, there are certain areas like patent infringements, etc., which necessarily will have to go to courts because they, you need an in rem result, which binds not only the parties, but which sort of binds the whole world. So obviously those areas of IPR can't go to arbitration or will not be as effective in arbitration. But other than that, I don't see why IPR shouldn't be a good hunting ground for arbitration.
Thank you.
It's not arbitrable. That's right. Therefore, the in-rem things can't go to arbitration. That's right.
Interject here
Sure.
just briefly. It's a little ironic because I sometimes use intellectual property disputes as an example of the long golden summer, because although the case may be different here in India, in a number of other jurisdictions, IP disputes, including patent infringement and even patent validity disputes, are arbitrable. And commercial parties very frequently include in patent licenses arbitration agreements, sometimes specialized arbitration agreements, providing for arbitration under WIPO, the World Intellectual Property Organization's arbitration rules, which are tailored specifically for intellectual property. My own view, you won't be surprised to hear, is that summer is coming for intellectual property disputes, a long golden summer of arbitrating disputes over patent validity and patent infringement.
Great, great. That's heartening to know. Anyone else who can think differently, not only of winter and summer, but also of autumn or spring? Any thoughts? Okay, so I think with that we draw an end to this panel discussion. Really appreciate each one of you here for giving us your candid views. May I request this House to put its hands together to show appreciation. Thank you very much. Thank you all for being a very, very patient and a lovely audience. Thank you.
Thank you all for this wonderful and stimulating session. It's now time for the most awaited time of the day, networking drinks. Just one request, I think so you all would have been handed the feedback forms. I request you to please fill them and have it placed outside. Thank you.